Okay, welcome everybody. This is one of our public lectures, and we're very pleased to have Colin Birss from the UK here, and I'll discuss more about Colin's background. So the way this is going to go, he said he has about 40 to 45 minutes. Then I will probably ask a few questions, and then it'll be open to you guys, the audience. And the way you do that, apparently there's a Q&A thing that you can see and click on and put in a question. And we're not set up apparently where people can just orally ask the question. But then I will read, or someone will read the Q&A questions at the very end of the session. We expect this to last roughly an hour and 15 to an hour and 30 minutes. It is being recorded for posterity. Okay. All right. You saw the thing, the future of civil justice. So Colin will be discussing that. Before we get to that, let's get a little background on Colin. Right now, I'll just do the professional background. Colin was called to the bar, found a fit practice in 1990. He practiced IP law and appeared before English courts, European Patent Office, and the European Court of Justice. 2000 to 2008, he was the standing counsel, the Control General of Patents, Trademarks, and Designs, which is as I understand it, the UK IPO office. And standing counsel is the person who represents, and Colin can correct me, in litigation, the organization for which he was a standing counsel. It's quite an honor. 2010, Colin, I'm saying Colin all because we're on a very first name basis here. Everyone would be going from sir to whatever, to whoever, to Lord Justice. But the transcript will fix this, put all this stuff into it. All right, so in 2010, Colin became a judge of the Patents County Court, which is now referred to the Intellectual Property Enterprise Court. And I can tell, because I was around thinking about these things then, is that court was basically not doing very much at all, even though they had a good person who was heading it. But Colin came in and really turned it around and made it a court that mattered for the people who needed it. He started out as causing trouble again. In 2011, he had this case of the bus on Westminster Bridge, a copyright case. I may be the only person in the world who thought he was right, but it was controversial at the time. And the fact of the matter is, UK started this whole thing, but was never that crazy about IP. The US followed up, and we were like devotees and loved it and loved it and loved it. And anyway, now I think we're pretty much, I would say, almost on the same level of interest and expertise in what we want. In any case, Colin is a leader in IP in the UK. 2013, appointed to the High Court of Justice, as I did 3 divisions, the Queen's Bench, Chancery, and Family, and Chancery is business law, IP. 2019, he was appointed judge in charge of the Patents Court. Patents Court is a subdivision of the High Court's Chancery Division. 2021, and this is a big deal, ladies and gentlemen. He's appointed to the Court of Appeal, and he became Lord Justice Birss. And I think that court does a pretty good job in IP because it has all these, basically the cases are decided largely by former, judges below who were doing IP. The one flaw I see about the British system, I think the Supreme Court could use some help in IP, but we won't have to reach that now.
Well, there is Lord Kitchen, but I won't interrupt you. He's doing a pretty good job, but anyway, by the by.
Yeah, but he's one of many.
Okay.
Yes, if you get one of his decisions, that's fine. Well, Kitchen is great. So that was nothing about. Does he have a first name?
David.
Yeah. See, and immediately Lord, you see, you go from Lord Justice, then it's Lord or Milord. By the way, in your court, the people speaking to lawyers, do they say Milord or what?
In court they do, yes. That's the way it goes.
Okay. No, David is fantastic. I wasn't speaking about him at all, but Colin, you interrupted me. Now I have to figure out where I was. All right. What do you think is who's supposed to be speaking here? Me or you, really? And this is probably what led to. He also appointed the position of Deputy Head of Civil Service. Deputy Head of Civil Service is a member of the Civil Justice Council and Rules Committee, which advises the Lord Chancellor, the Senior Minister of UK, responsible for functioning the courts on matters of civil law and civil procedure. And all of this may have background and everything else. We're happy to say that led to some interesting thoughts. The future of civil justice. And as you see in the thing that we sent out, 2 paths can be taken. What should we do? Or what can we do? Anyway, I'm looking forward to your talk, Colin. So you can start. Maybe out of deference to me, you should wait a minute before you start, but no, that's okay. You can start right away. And then we'll pick up again in 40, 45 minutes. All right. Colin, it's all yours.
Well, thank you, Hugh. Look, it's a pleasure for me to speak to you today. And I want to start by thanking Fordham Law School for inviting me. Now I'm going to speak to you about civil justice in general. And this is not really a law lecture. It's more important than that because it's about the legal system itself. And I rather think that the process of the law matters just as much, if not more, than all the substantive laws in the world. As Hugh has explained, my background is intellectual property law, and that has advantages and disadvantages. But one of the most significant advantages that it has is the reason I'm here at all. IP law is one of the most international areas of law that I know. It's been the subject of international harmonization treaties for well over a century. I'm referring to the Paris Convention in 1883 and the Berne Convention in 1886. Now, since that time, patents, trademarks, and copyright, at least in the industrialized world, across the world, have been pretty similar to each other. And I'm not even talking about the more recent versions, like in the 90s, the TRIPS Treaty. But that similarity between these different laws has profound consequences, which are not always appreciated. It means that judges from almost anywhere, not only the common law world, can have substantive conversations with each other. They can exchange views meaningfully. And most of all, it's possible to see how different countries deal not just with similar cases, but with the very same cases. And we can learn from each other, not only in relation to substantive law, but we can also see exactly how it is that people have done the same case in different countries. Now, what that brings me to is the next thing I want to say. I am not trying to tell anyone what to do. I'm going to try and explain what we do in my jurisdiction, which is the civil courts of England and Wales. And if it sounds like I'm telling you what to do, then that's not my intention. I'm going to tell you what I think we're doing, which is right, and what mistakes we may have made. And maybe that will help you in your courts. But just before I get into the detail, I want to make a final introductory point about Professor Sir Hugh Hanson. You may not realize it in this event, but you don't realize what an influential and remarkable figure Hugh actually is. He's been personally responsible for bringing together judges and practitioners from all over the world to speak to one another, not just for years, but for decades. And by facilitating these dialogues, and if I may say, gently teasing quite a few judges along the way, I would think Hugh has done more single-handedly for multilateral exchange and frankly for the improvement of justice in many countries than anyone else I know. Now, I'm not going to go on about it, but he has had a profound effect. Judges in one country now very often know judges in other countries who are doing the same kind of work really quite well. And that means that they read and cite each other's decisions on a scale which simply did not happen before. And it promotes consistency and it's good for the law. So I want to start by thanking Hugh, and I really hope he's blushing, and I can see he's turned off his video so you can't see. Anyway, the future of civil justice. Now, you've all, I imagine, heard of the poem, Robert Frost's poem about the road not taken, two paths diverging in a yellow wood, which one to take? And the poet, he took the path less traveled by. And he's looking back in the poem and asking, looking and saying, well, he took the harder road and saying it was the right decision. Well, I would say that the justice system today, where we are standing in that same place, we're looking into the future of how the civil justice system works, and we have choices to make, and they're not always easy ones. But the decisions that we're making right now are going to make a profound difference to the future, and we don't have the poet's luxury of hindsight. Before COVID, the courts in England and Wales were moving online. Many civil suits could be filed online. There was a digital court file, and that applied in pretty much all IP cases, but it certainly didn't apply in all civil cases. We did have quite a number of IT systems of various different sorts. There was a thing called CE file, which is used, still is, in the business and property courts, which is at the court level equivalent to the federal district court in the US. We have a system called MCOL, which is a bulk system for small debt claims. We have a system called PCOL, which is a system for mortgage repossessions and claims like that. None of them talk to each other. Decisions were being made in our courts, either without a hearing at all on the papers or, of course, at trial in the personal presence of all the lawyers and the litigants. And those occasions generally involved a great deal of paper. As I say, the trend was towards digitization, but it was very slow. An ADR was something that happened if you were lucky. Well, of course, since the pandemic, what we've been able to see is that the courts that had a digital file system did better than the ones which didn't. And in that period, and the use of electronic documents has absolutely mushroomed. We've all learned how to do that. And keeping the show on the road for the last year and a bit has been an extraordinary achievement and is due to the dedicated work of the court staff and the judges at all levels in our system. It has also been an incredible experiment. And I personally don't want to lose what we've learned from that experiment, the good and the bad. So let me tell you what I think is going to happen in England and Wales and where we will be in the next 5 years online. As I say, maybe that's true in your courts, but it certainly isn't true at the moment in England and Wales, but it will come. The digitally disadvantaged, in other words, a good number of ordinary people who can't use computers that well, instead of being permitted to file on paper, what will happen is that they are helped for their materials to be filed online. Every civil case will be managed online. Again, maybe that's true in your country. As I say, it's not fully true in mine. But in a few years' time, in our system, judges will have access to court files and will work on them online. And I don't just mean read the papers. We are rolling out now an online order making system in which a judge simply clicks on a couple of radio buttons, little buttons on the screen, in order to generate the case management order, the directions for a normal kind of case. They can add free text as well, but often don't need to. And the order is then available to the parties instantaneously. Now, this has posed some interesting problems. Many in our system are pretty wedded to the existing paper-based methods, partly because from their point of view, they can do their job, giving orders, by ticking boxes on a sheet and then handing the sheet to somebody else who then types up an order from a paper file and puts it in the mail and posts it to the parties. And there is a genuine concern that IT systems will paradoxically be slower, at least from the point of view of the judge. They won't be slower overall because actually it's far faster, not least because the time taken for the judge to finish the order on the system and the order to get to the party is 0. But as I say, from the point of view of the individual judge, it will take them a bit more time perhaps than they're used to, not always, but sometimes. And that will depend on the detail. So this has added a new phrase to the judicial lexicon: change management. Most judges I know, me included, went to law school and university a couple of decades ago or maybe more. And they're not IT developers. And they didn't know there was such a thing as change management, but there is, and they do know now. Also in the future, there'll be a funnel. The Master of the Rolls, who's my boss, talks about this quite a lot. What he means is that there will be a single point of entry for people to bring any kind of court action. They'll sit in front of an integrated IT system, and that will include all of civil and may well include all of the family system and administrative systems as well. And it will guide the user forwards. So it'll funnel a claim, say a small claim one way and a large patent case another way. And we're building exactly that now, and it's something called Case Builder. Now, the main beneficiaries of a funnel like this will be unrepresented parties, but the system will affect professionals as well. The integrated system will allow professionals' own IT systems to interact directly with the court. This uses things called APIs, application program interfaces, which means the law firm's own internal computer system will be able to talk directly to the court system and issue and defend claims and file documents and so on. And again, these APIs already exist. Our bulk issue system that I called MCOL is based on an API. Now, one of the things that we've done in our small money claims system is build in a timeline, a chronology, which the computer dialogue with the user generates as they answer questions. This very simple step has greatly improved the clarity of the cases which are being brought in our system by unrepresented litigants. But of course, professionals don't want to laboriously answer all these questions like that. But we don't want the professionals to use the system without the timeline. And we do want the professionals to use the system. So how do we deal with that? The answer is the API. What the API allows us to do, or will do, is for the chronology to be built seamlessly in the professional's own IT system and then be automatically uploaded into ours. So it's a win-win. Service of legal documents in this world will be electronic. There will be a provision in the terms which govern the professional's use and access to the court's IT systems that they accept service that way on behalf of their clients. And I'm not making this up, we're working on that right now. Now, today, the process of a civil case is governed by procedural rules, which parties routinely do not comply with, either by accident or not. And in the future, though, many of these things will be simply impossible not to comply with. Let me give you an example which exists today. In our paper system, parties are supposed to provide the court with the information necessary to give case management orders within 14 days of the case being defended. They routinely do not do it. And there is a cottage industry of judges and staff chasing them and making orders, peremptory orders, requiring them to get it done. But in our new online small money claims system, the parties can't fail to do it because the questions are posed as part of a computer screen dialogue. And you just can't defend a claim if you're a defendant without answering the questions. So the non-compliance problem has vanished. And it's quite a, in its own little way, quite a revolutionary little step. And let me tell you how alternative dispute resolution will work in this system. We haven't built this yet, but we are building it. It won't just happen at a particular stage of the case or be something which is only triggered by the parties themselves asking to do it. It might well happen before the claim is even issued. And here is an example. We're in the process of introducing, in fact, it's just starting right now, a pre-action IT system for certain kinds of claims, what are called whiplash RTAs. RTA stands for road traffic accident, and whiplash is the injury to your neck if you're in an accident. Now, this system is designed to facilitate the resolution of claims of that sort without going to court. And built into it is the possibility of getting the court to decide single issues, say liability, but then come back out into this ADR system to settle another issue like quantum. It's not yet fully integrated into our system, but it is only a matter of time. It will be integrated. But ADR itself will also be integrated into the process of the court case. So using machine learning and natural language processing, the system will monitor the file and be able to choose a moment to make a suggestion to a litigant. So, for example, it might say to a defendant, it might say to a claimant that the defendant looks like they've admitted they owe you the money, but they haven't admitted the full amount. Have you considered whether to make an offer for a lower sum? That's just an example of the kind of thing that can happen. And these dialogues will be possible at any stage. It may happen at the beginning or later, but the important thing is that it's integrated into the process. Now, the machine learning aspect of this, as you know, machine learning is just a form of pattern recognition. What it will do is learn when to raise these points, because the system will try it, see what happens, and once it discovers when the best time is to make one of these interventions, that's what it will do. That's one of the powers of this machine learning AI technology. But let's say the case has not been resolved. In future, every pretrial step involving the court, which today required a hearing, will take place remotely using video conferencing and with electronic papers. No doubt there will be rare exceptions, but they will be just that. I don't believe this is a denial of justice. We've learned in the last year and a bit that this is not only possible, but that in many cases it's far more efficient, not just for the court, but for the parties. And what about trials? And I don't mean jury trials. In this future, because we don't do jury trials in our civil justice system, save for some exceptions. In the future, most trials will be conducted at least partly by video conference, if not entirely. The trend for paperless hearings is gathering pace, but even if the advocates, the attorneys, and the judge are in the same physical space, which I think will be fairly common, other people, lawyers, clients, witnesses, may very well not be. And the ability to access the trial this way has very significant benefits for open justice, especially internationally. One of the things that's been very striking in the last year and a half is how many more international observers, I suppose is the right way to put it, are present in the cases in the patents court than they ever used to be, because you don't actually now have to fly to London to be able to sit in the patents court. That sort of advantage is something that I would be very loath to lose. And what about appeals? Well, they don't need witnesses at all. And so in future, there will be even more video conferencing. Now, what all this goes to show is to prove the point made by William Gibson, the sci-fi author, that the future is already here. It's just not very evenly distributed. And in fact, this isn't really the 5-year future at all. Most of what I've talked about in the last few minutes will happen in England and Wales within the next 3 years or so. And now I want to look a bit further ahead. Because once we have this sort of online justice system, more things are possible. And the big one is the use of AI, machine learning, and natural language processing. I mentioned our case builder system. If we get it right and use natural language processing and good machine learning tools, the front end of our civil justice system will eat some lawyer's lunch. The formulaic written documents, in England we call them pleadings. I never quite know whether pleadings is the right word for the States, but the formal written documents in simple cases will simply cease to exist. Unrepresented litigants will be able to go straight to the court online, They will be asked appropriate questions about why they're there, what is their problem, and who they're trying to sue. And the formal pleadings, complaints, if that's the right expression in the US, will be generated by the IT system. As I say, as I've already explained, we're already doing this without AI. Just think how effective it would be when we use these tools as well. Now this, as I say, will cause a reduction in what you might call easy work for trainee lawyers. But it doesn't mean that legal advice is abolished, and it certainly won't abolish the need for representation either. And just note what I've just been talking about. This sort of use of artificial intelligence and computing does not involve the computer deciding the case. I'll come back to that in a minute. But just sticking with this case builder idea first, one of the real problems with it is that it needs to be kept up to date. As the law develops, you need to make sure that the system asks the right questions in the right way. And that is costly. So, well, I hear you wondering, who's going to pay for all this? Governments? Well, no, perhaps there is an answer to that as well. The answer is not necessarily. And this is where another convergence of what's going on becomes really interesting. I mentioned our new whiplash system. This is a gateway IT system for certain minor traffic accidents, as I've mentioned. And by calling them minor, I should say I'm not belittling the accidents for the individuals who've had them. And as I explained already, the claimants, the plaintiffs, have to bring their claim in that system before they go to court, and it will be integrated into our IT system. It's governed by protocols, rules, in other words, which have been issued under the authority of the senior civil judge, the master of the rolls. And judges have been very closely involved in the design of this system to make sure that it works properly and fairly. But the system has been developed and is run by the United Kingdom's Motor Insurance Bureau, funded by the insurance levy, which allows claimants free access to the service. And that takes me to two questions. First, what is civil justice for? It's not an end in itself to make jobs for lawyers and judges. And perhaps, unlike the criminal justice system, civil justice is not something which the state does to its citizens. Rather, the state's role in civil justice is to be a referee and to make sure that disputes which inevitably arise are resolved fairly and quickly. And the second thing, maybe whisper it, perhaps there is a market for dispute resolution. We're already seeing more or less privately funded dispute resolution systems coming into existence. I'll give you another example, is the well-known eBay dispute resolution system, which I'm told handles something like 60 million cases every year. Now, my point is that the referees do not build the football stadium, but they do regulate how the football matches are conducted within it. So imagine this. Imagine we have online systems which allow citizens to try to resolve their civil disputes without going to court. Call it mediation, call it ADR if you like, or ombudsman, or some other things, but I'm going to call them generally a dispute resolution system. These systems can have AI-based case builder logic built into them to help the parties clarify their case, and AI-based mediators to help them settle if they can, and many cases will settle that way. But if they can't agree, they will go to court, as is every citizen's right. Now, these DR systems, what they need is a direct interface, an API, with the court's online file system. And once the claim is issued, the management of the court case and everything else is done online or not, as the judge decides. But the court system doesn't have to be particularly complicated. And the reason why not is because all the hard work of clarification and classification of the dispute, which was undertaken in the dispute resolution system, will be available to the court. And none of this stops anybody from having without prejudice negotiations as well along the way. But the important thing is that that hard work, the heavy lifting, is done in these DR systems. And critically, the state's role, including the role of the judiciary in terms of court rules, is to regulate these DR systems, not necessarily to build them or run them. And none of this takes away the citizens' rights of access to justice. Indeed, it's quite the opposite. It facilitates it. And again, at the risk of repeating myself, my reference to William Gibson, the building blocks of this future are already here. Does this mean an end to the legal profession? Well, of course not. It does mean the end to some lot of legal drudgery, but there'll still be a need for good lawyers to help people both with advice and representation, as I've said before. And that brings me to the next question. What about AI judges? If so much else can be done by computer, surely the judge could be a computer too. Are human judges going to be replaced by computer facsimiles? Now, before I go any further with that, I want to mention Socrates. That's not the name of a computer system. I mean the ancient Greek Socrates. And what's he got to do with this? Well, as you may know, more or less all we know about Socrates actually comes from what Plato, his pupil, wrote down. And one of Plato's works, which survived to the modern day, is called the Phaedrus or Phaedrus. And in it, Phaedrus and Socrates are having a dialogue. And strikingly, one of the things they discuss is the introduction of new information technology and how it's going to make a mess of things. And Socrates was the one who was against the new information technology. He thought that this new IT would replace what was important with a mere facsimile, a semblance of what really mattered. Now, do you know what it was? This new information technology that Socrates was so against was writing. In particular, he was against writing stuff down, which ought to be learned by heart. He favoured the oral tradition of memorising what mattered. Now, with the greatest respect to Socrates, I'm glad he lost that particular argument, although maybe it did take a few centuries. So, are we wrong about AI facsimile judges in the same way that Socrates turned out to be wrong? Well, I'm not so sure. As I said, the state's job is to provide the referees, and that includes the judges. And the judge's job is to decide the cases when the parties can't agree. But it's obvious that a machine learning system could produce an outcome in a case. But that raises a couple of questions. If all you want is outcomes, well, you can toss a coin to give you an outcome. So we know that's not enough. We know we need more. And that more is that the decider, the deciding person, is invested with a level of trust and acceptance by society. On the other hand, why should we assume that acceptance and trust will not be invested in a computer? After all, in the days when we used to fly across the Atlantic Ocean, pre-COVID, we trusted an autopilot to take us most of the way. But a major objection to this so far, these AI judges, is the hidden bias in the training data used for these pattern recognition-based machine learning systems. And there have been some famous examples. One of them, I think, was the compass system, but the details don't matter. But think on this. What is more acceptable? An IT system for which the training data is open to scrutiny, or a human system for whom the inverted commas training data is actually rather opaque? Now, again, we're all aware of public debates which suggest things like a hungry judge before lunch makes different sorts of decisions on average from a well-fed judge after lunch. So is it really so inconceivable to think that in future people might trust an IT system more than they trust a human one? But here's another thing. What judges really do is not just provide outcomes, they give reasons for them. Now, at the moment, I know people are trying to see if they can do that with AI, but at least as far as I've seen, it's a way off. On the other hand, from what I have seen, I really doubt that in the end there will be insuperable technical obstacles to using AI to produce a facsimile of a judge, including a system which gives reasons. Generating post hoc reasons, once you know the outcome, is just another kind of pattern recognition. But actually, I think we're a long way from introducing AI judges for a more fundamental reason, coming back to what the civil justice system is actually for. Maybe it's not just about the provision of a referee. Maybe it's about justice. And justice demands that the losing party feels that they have been heard. And I'm not naive. Many losing parties feel the absolute opposite. And for what it's worth, I will confess that when I was at the bar, I really hated losing and usually thought that was because somebody hadn't been listening. But what we need in order to provide a system of access to civil justice is to guard the aspects of the legal system which support respectful acceptance of the outcome, particularly, of course, by the losing side. That counts for a very great deal. And looking at it from that point of view, I think human judges and lawyers to present cases to them will still be employed for a very long time to come. Or putting it another way, the fact that something can be done on a technical level does not mean that it should be done. The benefits of the online world will be very significant and the changes will be profound, but I believe we're still a very long way from an entirely automated court system in which all there is a computer. So I'll end with this. There is a better future out there. The building blocks are being built within the court systems all around the world. And we need to engage with these debates right now because the changes are happening right now. So coming back to the poet, we are standing in a yellow wood. And the easy way is to put our heads in the sand and not confront all of this stuff because it looks complicated or difficult. But the right way forward is to step onto this harder road and engage with what is happening. We mustn't sit back and let others decide how the legal system is going to develop. Thank you very much. There you are, Hugh. I'm done.
Thank you, Colin. You know, you said you're going to do 40 to 45. You were much shorter than that.
I'm sorry.
Fortunately, I'm actually still in the room. I might have been somewhere else. I don't know, but no, that was great. Okay, so let me ask a few questions. And by the way, ladies and gentlemen, go into the Q&A and put in a questionnaire. That's our system isn't set up for basically people orally asking a question. Okay. Which countries? I mean, if you look at the systems of countries, UK or US, you know, maybe way ahead in all this, but there are many, many countries in the world in which this would be probably not possible for a long time. So is this going to lead to, what will that lead to? That lead to more people using the US and UK? Or if I'm just want to slow up and more trouble and everything else, why purposely go to a backward country in these things under the old system? Do you think any of that strategy will happen?
Oh, I don't know. I mean, I think I've got to say what I'm really focused on mostly is the kinds of case which are not major international patent cases where people are fighting in multiple jurisdictions and trying to, you know, it's a world that you know and I know of where you have a dispute where you sit and think, well, shall I take this case to the US court, the Japanese court, the courts in London, the courts in China, whatever it is, and you play as the big players in this world, whether it's the telecoms companies or the pharmaceutical industry or whatever, and they think about which courts they want to fight in. I would be surprised if what I've been talking about has a major role to play in that, but maybe it does. I suppose it does. What I'm much more interested in now, in wearing my Deputy Head of Civil Justice hat, is the cases which are, you know, US citizens suing each other for some reason, or UK citizens doing that. It's the local cases. They're the ones that need to be helped, and that's the bit of this that I'm interested in. And talking of other countries, I mean, let me give you two examples of countries where I think there's some very interesting stuff going on. Korea. I think the Korean court system, particularly the patents court, is really using IT in some interesting ways from what I've seen. And another one is, I think, and I will get this wrong, it's Estonia. The Estonians are also doing some of the things. And those are, you know, to be frank, those are not places which, in the sort of conversations that we normally have in Fordham, are places people look. And there's interesting stuff in those places.
Yeah, that's very interesting. This is going to, though, reduce the number of lawyers needed and staff needed.
Well, it may reduce numbers in a sense. I don't think it changes the work that interesting work that lawyers do, but what it does is takes away some of the boring stuff, and maybe it may well in that sense affect profitability, because you won't be able to just do easy jobs and charge a lot of money for it, because the easy jobs will be done by machines. I mean, IT machines.
Well, yeah, and there's a bunch of lawyers who don't want the sophisticated, they want the easy. And I'm concerned that they will then say, this is disrupting the system, whatever, I don't have a job. So to what extent of just people wanting to hold, and this is true of AI all over the place, hold on to their job might have an effect of how quickly we can get into the system?
Well, I don't know. I don't know for sure, but if you look at the situation that we're facing, certainly in my country, there are an awful lot of people who have legitimate civil disputes which are too low value for them to be able to afford a lawyer anyway. So they need their disputes resolved properly, fairly. And if you're someone who's going to bring a case to the courts in England, which is worth, let's say, £1,000, £1,000, that's not a case that really any lawyers can add value to anyway, because they couldn't advise or represent someone if that's the value of the dispute. And the fact that someone has a dispute of that value doesn't mean it's a small case from their point of view. My experience is the only people who bring cases like that, I mean, there are some people who do silly things, but the people who bring cases like that do it because for them, that amount of value is significant enough value to be worth the significant effort and trouble of trying to take it to court. And lawyers can't help them. So a system which helps them is good for everybody.
All right, so let's talk about, the whole generation. Technology is nothing. They can do anything else. But then there's a whole group of people, maybe from 60 on, who technology, the joke is that grandchildren come and good, they can fix all this stuff for us while they're here. So is there some, and also the view about science and technology. So some people who should be getting vaccines aren't getting it. So is there an aspect of this of, let's say, older people and all, and yes, it would help them, but for whatever reason, Mary, I just can't get involved, I don't understand it, or this, is going to need more actually explanation for that part of the population to.
Well, I think you're right. No, I think you're absolutely right. I mean, we all, we all have that experience. But to me, what is obvious is that so much of the world, and what I mean is our interactions, not just speaking interactions, but business is moving online anyway. So it's very strange actually that our systems for resolving disputes like that are not following suit. But I agree with you clearly, and I mentioned what I used the rather awful expression digitally disadvantaged. I mean, there's clearly a cohort of people who need help, and there always will be, because it's not just elderly people. There will always be people who need help, but then that's always been true. And the interesting challenge is how do we help them? And I think what I think is interesting to me is, in a sense, there's a pivot going on. So what used to happen is that the non-digital people, if I could call it that, ran the world, and so the system worked that way. And that's coming to an end. It's coming to an end. The digital is where the world is now, and we need to help the non-digital rather than it being the other way around. And that's only going to grow.
You raise an interesting point, is when you lost the case, you thought there's something, either they didn't understand it or this or whatever. And, I clerked, and I ran into this to some degree, is coming out of law school, I was all facts plus law equals result. And then I clerked with my district court judge and said, let's sit this. And his view was, get in charge of the facts. The law takes care of itself, which of course, I spent 3 years trying to learn the law. That's ridiculous. But what he was saying is he knows who should win. and creating without saying it, creating the doctrinal path was fairly easy. So you have examples. So then I go, he did this case and I worked with him and I knew exactly, we worked on it together and we had to get them to come in from some settle order or something. And then they're in the courtroom and he says, Hugo, go bring them in. So I go and of course I'm trying to listen to every lawyer. So I listen to one and says, oh, Susan, you just killed on us. You killed on us. Then I go the other half of to get them. They said, judge just didn't understand the law. And they didn't understand. They both were irrelevant to it. So dissatisfaction with results in an AI world, we have to be concerned about that because people may blame the AI and it isn't the AI. So is there some way to, I don't know if this is, are AI judges going to be better, more understanding?
Well, this is, I mean, this is the point that I was trying to articulate, is that I think I would say we do need to be careful, because if you simply assume that people are better, then you're making an assumption which is open to question. AI system, one of the, well, we know this, but it's worth just drawing this out. What we mean by AI normally is machine learning, these machine learning systems. And the way they work is that you have training data, and they're systems which basically recognize patterns. You teach them with the training data and you give them an outcome, and then they learn how to make that outcome happen from a given set of inputs. And that's what these AI judge type systems do, and they exist. We all know they exist. You can do it. You can look at patent cases, and you can feed it into a system, and it'll predict whether it's going to win in this situation or that situation. And one of the major criticisms of those kind of systems is that is the built-in bias in the training data, and these awful examples of the case, and forgive me because I don't know the details, but what I've read about it is there was an AI system that was used in the States to aid sentencing. And if I'm getting the detail wrong, I apologize. But the principle, I think, is important. This was a system set up to aid sentencing. And the difficulty was that it had been trained on outcomes and data relating to particular cases. And unfortunately, what it was doing was it was actually reflecting the truth that was in the training data. But what that training data included was inherent biases, whether it was racial biases or some other inappropriate discriminatory biases. And obviously that's not good. And so that's why there's a problem, or perceived to be a problem, with AI. But the answer to it is openness about the training data. If you have open training data that is what's driving your AI system, then you are in a more transparent system than you would be with human beings. Because then it's apparent what the criteria are that are being used, and the result follows. And that's where, to me, there is a serious question that needs to be considered carefully, because we can never, as human beings, we don't have the training data, my training data, whatever causes me to make a decision in the morning or the afternoon, or what I did. And that's never going to be something that we can be explicit about. And you can see coming, we're not there yet, but you can see coming down the track a situation in which it's possible to say, well, here is an AI decider in which you can see what the criteria it's using are, and you're getting a more open system deciding the case this way than you would with a human being. And I think we've got to be careful about that, because I can see it coming. It's not happened yet as far as I know, but I can see it coming.
Okay. All right, let's go to the Q&A. I think it's just, okay. Are you familiar with the PACER system used in federal courts? Do you see any strengths that it has that are worth replicating in other court systems? Weaknesses that should be avoided?
I'm afraid I don't. Someone will have to tell me what the PACER. Do you know? Can you tell me what the PACER system is? You? I don't know.
The PACER system.
I've heard that name, but I don't know.
Yeah, I just know the PACER system is how I can get access to federal opinions, and maybe more sophisticated and other such like that.
Yeah. I mean, we can. I mean, if it's an electronic filing system, then we have similar electronic filing systems in the UK. I mentioned one called CE File. CE File is a system where nowadays, for example, in the Patents Court in London, all filing is online. Parties have accounts, they log into the system, they can file all their documents, and in appropriate cases, you can get documents online if it's a public document. That's all possible. The judges access the files online, and the diary system is all online internally. And that's an integrated online file system. But what it isn't is any more sophisticated. So it's and I don't know if PACER is more sophisticated than that, but the thing about the online file systems is that they are effectively, if I can use that expression, dumb systems. They simply hold all the files. What we're building in the small money claims system I'm talking about, and in a damages system that's just been set up really last month, is systems which are more intelligent. They, for example, they know what state the case is in at any given time, and there is much more machine readable information about the case built into the system, and that's why you can start doing all these other things that I'm talking about, because you have these more sophisticated systems.
Okay. All right, let's go to the next one. If we have an AI judge, how do you envision the appeal system? Will we have another computer to review the AI judge's decision? I don't know about type answer or answer live.
No, I can. Well, let's. I don't know about that.
Yeah, well, just answer it. Yeah.
Yeah. That's a really interesting point. Now, I think to me the answer to that is that raises two separate thoughts. One thought is another thing that you can see coming down the track is that you do have an AI judge system for the first instance, and then appeals are decided by people. That's a model which I've heard a number of people talk about, and you can see that might be acceptable, and you can see that to some people, and you can imagine that, of course, if people don't appeal, then there's obviously a level of satisfaction with the result, maybe not necessarily total satisfaction. Obviously, many people don't appeal, even if they feel they shouldn't have lost. But then you're using your judicial resources only for the appeals, and I see that, and that takes me to the other point, which is one of the justifications I've heard for why there shouldn't be AI judges is because, especially on appeal, part of the appellate function is the development of the law. You say, okay, well, first instance judges are there to find the facts and decide the case according to whatever the law is. And the appeal courts are there to correct error when they find it, but also, and more importantly, to develop the law and maybe in that sense be more creative at a legal level than you need at your first instance. And I can see that. I don't think that's an unreasonable way of putting it. But that theory doesn't preclude, I don't think, having AI judges either, because what is it when judges are creatively thinking of new developments in the law? It's just more pattern recognition. You could set up an AI system that's designed to find patterns like that just as well as you could have an AI system which finds answers to the first instance cases. So I'm not sure that, although I didn't mention it, I'm not sure that appeals are any more immune to this than the first instance, to be honest with you.
Okay, next one. Please explain how your DRAI system might apply in trademark infringement cases to determine if one mark is infringing another. Thank you.
Okay. Well, I mean, what I have in mind there is so my DR system is a front-end system which, let's say, has been built by some private provider and is regulated by rules which are controlled by the state and the judiciary. And a small business has a trademark and they go on the system rather than approaching their lawyer, and they type in, I want to my complaint is I don't like the fact that someone's copying my trademark or some other expression. Normal human beings say copying trademarks, even though trademark lawyers don't use that expression. And the computer asks some questions. So, do you have a registered trademark? Could you tell me the number? Tell me the number of your registered trademark. What's the show me? Upload a picture of the product you're complaining about. All that sort of thing. And the first critical part of what I'm talking about is that the person who's using this as an individual didn't conceive necessarily that their case is a trademark infringement case. I mean, in the real world, no doubt they did, but they don't have to have done that. What they do is that they come to the computer and the computer works out itself that it's a trademark infringement case and asks the appropriate questions. And then eventually, it wouldn't take very long, the computer has now got the registered trademark, the defendant's product with a picture, and is in a position to, based on an AI decision maker, based on training data from the last 100 years worth of trademark law, look at the two logos and say that infringes or that doesn't.
In trademark cases, it used to be judges didn't know anything and juries didn't know anything else because nobody shopped, the judges didn't shop, nobody. Now everybody's a consumer. I think basically, this is my guess, when a trademark case comes into a court or anywhere, you just ask the public. They don't say, I don't know trademark law, I don't know. They'll come up with an answer, who should win. They look at the two and it's almost instantaneous. Hold on.
That is a great ringtone.
Yeah, this is ridiculous.
You know that Robin Jacob calls those things cell phones because that's where you need to be sent if it happens in court.
All right. Okay. I was distracted. Probably no one else was distracted. Okay. So we're done with that then. Oh, no. What about the almost instantaneous? Yeah, it's similar or not similar enough. I mean, almost you can't stop thinking about it. Is there any truth to that? I mean, in fact, is there any truth that judges make up their mind pretty early on these things?
Well, I think it's okay. That's interesting. I mean, how do judges decide cases? There's a really interesting question. I mean, speaking personally, I don't know how I decide cases. What I know is that the more of it I've done, the more I find it harder rather than easier. Actually, you get an instant reaction to a case, and one of the things that you learn quickly, I think, as a new judge, is that you get an instant reaction, and you shouldn't be scared of the fact that you get an instant reaction. Rather than the first time I did it, I was panicking, thinking, "Oh, but I'm not supposed to have made my mind up so early. I need to listen." But you learn that, of course, as human beings, we're all human, so you get an instant reaction, but you learn to suspend final judgment, because the more you do, you then discover that you listen to the arguments and you read the materials and your views change. And that's how it works. But that's how human beings work. No doubt that's not how the IT works.
To what extent do you judge other judges when you read their opinions about and put them in a box of good, this, or countries in terms of the quality of the judicial decision making? Is that something you can't avoid?
I think you can't avoid. Well, I mentioned this. I hope you were blushing when I mentioned it, Hugh. But I think what you've done in Fordham is absolutely outstanding. And in particular, I mentioned this already, but just to pick it up because it answers your question. I think by having a place in which judges meet each other and talk to each other from other countries, what that has done is demystified the judicial systems from one country's point of view in another country, so that when you're reading, if I'm reading a decision of the Supreme Court of the Bundesgerichtshof in Germany, and I see that it was a judgment that included some names, and I won't embarrass anyone by naming names, but as you will expect in Europe now, the judges who do patent cases know each other. And it's a different experience to read a judgment that's written by somebody you know and you've met and you've spoken to and you've discussed things with. Is a different experience from reading a judgment which is from someone who you may know of, but you don't know them for sure. I mean, if you look at old judgments, you know, I mean, there are judges with reputations. I mean, in the UK, American judges like Learned Hand and Cardozo are people who are incredibly famous, and you read what they say and you take it, you take note of it. And there are other you know, names of senior American judges that are just names I just don't know, and you don't react in the same way when you do that. And that's
All right.
to being a human being.
Good. All right. Thank you. All right. Let's. Have we left the world of adversarial litigation and are we creeping slowly towards the inquisitorial system practiced in civil law jurisdictions?
Well, that's an interesting question, isn't it? I mean, I would say, well, maybe we are, but the way it's happening is by asking the right questions. You're helping the litigants explain their case. And if the system, as I mentioned, the $1,000 case, I'm not criticizing, I really am not criticizing lawyers, because it's perfectly obvious why professionals can't make a realistic business model which involves charging people to advise them in a case of that value. But those people still need help and they still need their cases decided. And moreover, as a legal system, we need their cases to be presented in a way which is efficient. Because otherwise what happens, and all judges know this who do that kind of work, is the judge who ends up doing what is in effect an inquisitorial process, because you have the litigants in front of you and they haven't articulated a case that makes any sense, and you have to ask them questions in order to extract it from them. And that's what judges are doing every day in every county court in England and Wales. And I imagine they're doing it in every state court in the States. It's something that has to be done. So if you have a tool which allows that to be done before they get there, then that is a better system.
Okay. Inspiring ideas. What do you think about AI systems that would assist judges in applying complex concepts, e.g. providing a recommendation on non-obviousness and better step on facts? Yeah. Could such systems have an enhanced harmonizing effect internationally?
Well, I think I think that's interesting. One of the suggestions that is heard as a sort of mitigation about AI is the idea that it should be assisting the judges rather than replacing the judges. And I understand that, but I'm a bit of a skeptic, to be honest, because I think there's a fine line between assisting and you're effectively delegating the decision. And I'm not, you know, we all, as judges, we all know the difference, obviously, but it doesn't alter the fact that if you have you've got a difficult case, a difficult call to make on, let's say, obviousness or something, and then there's an AI system which says the answer is obvious or whatever, and you're going to be influenced by that. Now, does that influence? Where does influence end and the AI making the decision itself begin? And in some ways, I think it's part of what I'm trying to say is that it's almost paradoxically more honest to have an AI judge than to produce a system which has AI assistance, where you pretend the human judge is still ultimately doing the same thing they were doing before. So I'm not so sure about that. But will it have enhanced harmonization? Well, I guess so. That's true. If you can agree on the training data.
All right. It's similar. Especially in this country, district court judges are incredibly busy, and the main goal at first is just to get rid of the case and move on. Magistrate judges are there, or now theoretically they can overrule a magistrate judge. Almost never happens, because this is a godsend to that district court judge of, I don't have to do this case. So in AI, even if it was advisory, is there a human instinct on this of, yeah, look, this says that, write it off. I'm talking about first instance now, and I'll move on.
I mean, I think there is a human instinct is the answer. That's why I think one needs to be careful with doing it in that way. That's what I'm trying to say.
Okay, yeah, all right, yeah.
Right. Yeah, Pacer. Well, thanks to William McNichol.
Pacer is a system that allows filings by parties, issuance of dispositions by the court, provides for notice and service, and allows also often made available to the public. Thank you, William.
That's awesome.
I appreciate your thoughts. I'm just thinking, we're running, yeah, okay. I appreciate your thoughts on pre-litigation ADR. That is a system that allows parties to attempt resolution before filing with the court. Did we already do that? I can't even tell anymore.
I think so.
Oh yeah, if AI judges are the trial judges and humans are the appellate judges, won't that restrict credibility determinations to computers? Isn't that far beyond the capability of current or foreseeable AI systems?
Well, I think that's a very fair point. I mean, one can see why the idea that you can assess credibility, a computer assesses credibility, seems hard. But that takes me back to what I was trying to explain more generally. It's about what it causes you to do is think about what the system is actually set up to do and why. And I rather think the truth is that we as a society are prepared to accept human beings making credibility assessments, even if when you analyze it, it's these, we all know that assessing credibility is extremely difficult, and difficult sometimes is a euphemism for very unprincipled, not always, but often. But nevertheless, perhaps the truth is we would accept humans assessing credibility, whereas to try and expect a machine to do it is just something which we won't accept. But I don't know about that. If you say, well, if you're taking a case as one often does and says, well, how are you assessing credibility? Part of it is because you look at the documents and you see what the person is saying and you assess it against the documents. Computer can do that just as well. And maybe an AI system, wouldn't be distracted by the things which I imagine in the States you've got clear authority. We certainly have it in this country that judges need to be very wary of putting weight on all sorts of what I'm going to call metadata. That's not what the cases call it, but hesitancy by a witness. Hesitancy doesn't mean necessarily that they're lying. All kinds of things like that. The thing with the IT systems is that you can actually make sure that they don't take that into account, because you can set it up so that it never knows what the witness was doing that you think is not something that's relevant to credibility. So I don't see that as a catch-all answer.
Well, one of the things about credibility, and the reason why you're supposed to defer, normally speaking, if the judge is saying, I think someone is lying on the stand or something, is because they're looking at the person and they make that determination. In terms of AI, they're not saying anything different than you're saying. So can you still have this view that if it's credibility, defer to the AI lower court decision, because they're in no better shape of determining that presumably than you are?
No, I agree. No, I think the appellate thing with if you're going to have AI, it doesn't make, the way you do appeals is different. And that was something that's been mentioned before. I think that's a really interesting point.
Okay. Is there any policy work done in the UK on AI systems, e.g. justice processes? And if there is, what does it indicate as far as to deal with bias?
Well, I've been involved in some of this, and I haven't got an answer to give you a simple answer to that question. If there is policy work, it's not something I know much about, so I can't tell you any more than that, I'm afraid. I'm sorry.
Sorry, Turka. Okay. Last question. If a witness, almost the last question. If a witness at trial gives his evidence remotely from his dining room, how does a judge satisfy himself that the witness is not being coached by someone sitting next to him?
Yeah, well, that's a good question. I mean, I would say the answer to that is one needs to be careful how you set up these kind of remote hearings. But we've all done it. We've done it now. And one of the ways you do it is maybe you have it so that the witnesses, if you are having remote witnesses, they do it from a law firm's office where you can tell because the lawyers are there that they're not being coached. And that's just an example. It's not the only one, but it is one which is being used now quite routinely. Excuse me, but that's I completely take Robert's point that if you simply have a system where the witness is giving his evidence remotely, as you say, from his dining room, that's a factor one has to bear in mind. But it hasn't that point. The other point I want to make is that perfectly sensible point hasn't stopped innumerable trials taking place in this pandemic time where that is at least a theoretical problem, and it doesn't appear, as far as I can see, it doesn't appear to have been a real problem on any major scale.
All right, then that's a question. If you don't see that as being a problem, because my advice to somebody on a trial is to get the witnesses and all before the judges. And if you're saying, no, I mean, in a courtroom with all the stuff that's going on like that, there's no reason now to show up, and you might as well do it remotely if in fact you're saying it really, in your practice, it doesn't make a difference whether the witness is in Iowa or is in front of you. Well, then that's something.
Yeah, I mean, it makes a difference sometimes. I'm not saying it doesn't, but what we've seen is that you can have the witness in Iowa when you have a problem because we can't fly witnesses across the world at the moment. We seem to have suddenly discovered that actually having the witness in Iowa and the judge in London isn't as big a problem as we thought it was.
What about oral argument? We have is it important for you to see the judges before you? Or can it be remotely on the screen? Does it make the slightest bit of difference? Or do you pay a little bit more attention if there's a body in front of you talking? Tell me about that.
Well, I don't know. I mean, I think it's a different experience, but it's not. I don't think it's as simple as saying one is better than the other. I think when you get used to it, this kind of interaction actually is extremely effective. Now, whether it's let's be real about it. No one is going to suddenly turn off people turning up in physical courts tomorrow. That's clearly not going to happen. But and what is very telling is certainly there's a cohort of advocates. I'm sure there is in the States. There certainly is in the UK who've learned their trade in a physical courtroom, and they got to a certain age and they thought they knew how to do it, and suddenly this year they discovered that all the little things they knew about how to do don't work on screen. Whereas you have another cohort of younger advocates who hadn't got so much experience of the physical courtroom, and they've learned their trade doing it this way in the last year and a half, and they're pretty good at it. So it's not necessarily better or worse, but it is different.
Am I detecting a little bit of a bias against older advocates here?
Certainly not.
Okay. All right. Okay. I think last question. An AI system has to be trained, which includes a component of evaluating the validity of conclusions and trying to ascertain what may have gone wrong. Presumably, over time, an AI adjudicatory system will become more refined in its ability to make sound conclusions. What does that mean, if anything, for early participants with a less trained process?
Okay, well, I think I understand the point that's being made is that you say, well, an earlier system maybe made more errors, but that's why all systems, whether it's the legal system or anything else, if it's appropriate, have error correction mechanisms. Now, I'm now a judge in our Court of Appeal. What that means is I'm part of our error correction mechanism. And we need to have error correction mechanisms, whatever we do. And that's the that's the only answer I can give to Victoria's point.
Okay, I'm afraid that's the end of the time. So I want to, Lord Justice Birss, you can see we properly put the title there. And we've said the recording, everything else, it's going to end at 1:15. So thank you very much. And thank you for everyone participating. Now, Anderson and Andrew, I'm sure we can figure out a way for Lord Justice Birss to answer that on writing, but I think it's important that we, because then more other people would be, and we really have to have people planned on coming in for a certain amount of time. So we will try to get these questions answered for you. In the meantime, thank you very much, Colin. I really enjoyed this. I hope you did. And I hope that the people watching did. And I look forward to when I can see you live. Although, no, maybe it's better not seeing you live. Maybe a Zoom call is actually better than seeing you live.
Maybe. I'm sure a visit to London, if you can come, would be very welcome. I'll offer you tea anytime, Hugh.
All right, excellent. Okay, take care. Very nice seeing you again.
Very good to see you. Cheerio. Thanks very much.